Hi, my name is Adriana Shabbat, and I will be talking about Priceline's terms and conditions. Um, Priceline's terms and conditions are actually really straightforward and quite frankly pretty blunt. In Part 1, Section F of Priceline's terms and conditions, it states, "We will not process your notice if it is incomplete. Priceline.com reserves the rights to remove content on the site alleged to be infringing without prior notice as its sole discretion. You may wish to seek legal counsel prior to submitting a copyright infringement notification, and you could be held liable for alleging false claims of copyright infringement." Now, this only pertains to copyright infringement issues, but it is clear that Priceline does not mess around. The introduction for the terms and conditions also says, if you do not agree with any part of this agreement, you must discontinue use of this site. By simply using Priceline's website and their products, you automatically agree to their privacy policy and their terms and conditions. There is no checkbox to agree to these terms, but it is a valid contract since the policy is posted and states if a consumer does have an issue, then don't use this site. However, an average consumer doesn't think about these things in the first place because, they're generally willing to accept any conditions in order to get a service or a product. A survey from Deloitte revealed that 90% of consumers accept legal terms and conditions without reading them, and it was higher between the ages of 18 and 35. That was about 97%. Priceline does not have the checkbox for their terms and conditions. The website is considered a browse wrap agreement, where the service providers put the terms and conditions agreement somewhere on the site. In this scenario, the mere use of a website is seen as a user's agreement to a set of terms and conditions. If a dispute reaches court, most judges are only willing to recognize click wraps as contracts, which have a better chance of standing up in court because a user has to check the box to agree. Now, in my opinion, I agree that browse wrap agreements should not hold up in court since it is not readily available to users unless they specifically look for them. If a user does have a dispute with Priceline does seem reasonable. Their terms and conditions state, if you have a problem or a dispute, we will try to resolve it. If we are unsuccessful, you may pursue your claim as explained in this section, in which they then proceed to explain the steps that a user should take. The user must provide a notice to customer support within 2 years of the issue, and within 60 days, if Priceline cannot settle the issue, the user may seek relief through arbitration or small claims court. And arbitration is generally final and binding, and the user may not join another person's claim. When a user decides to go to court other than small claims court, the claim must be filed only in the United States District for Connecticut. So yes, a user does have the right to sue Priceline, but only if Priceline is unable to resolve the issue themselves within the 60-day time frame. Priceline does do a good job at covering themselves legally, but there are a few points that may not hold up in court. Also, a few points that me personally I do not agree with. First, Priceline chose a browse wrap agreement instead of a click wrap. In a court, a judge could rule against Priceline because the terms and conditions or other policies do not give the users reasonable opportunities when purchasing products or services to read them, and they had no chance of definitively clicking, yes, I agree to Priceline's policies, and then proceed to read them. Second, Priceline reserves the rights in its sole discretion to amend, modify, or alter this agreement at any time by posting the amended terms on this site. In simpler terms, this means that Priceline can change the terms and conditions or other policies anytime they want, and they do not give advance notice to users, and they do not send out notifications via email, through the app, or otherwise when the terms and conditions have actually changed. As the Electronic Frontier Foundation summarizes it, a A terms and conditions agreement should present the terms to the user before any payment, allow the user to easily read all the terms, provide an opportunity to print, save, and/or copy the terms, offer the user to decline the terms, and ensure the terms are easily located after the user agrees. All these suggestions that the EFF presents, Priceline pretty much does the opposite, and I disagree with Priceline.